Your Honor, in, I believe it's item number 1, the matter of Sanchez v. Larson. I don't see Ms. Winkles on here yet.
I am here.
Oh, there you are. Okay, I believe we've agreed to set this over for 2 weeks in order to allow the guardian ad litem to complete her report. As you're aware, there's an extensive amount of information here, and she would like to be thorough.
Sure. Ms. Winkles, any concerns setting it over to the March 13 docket?
No, Your Honor, that's agreed.
Great. And then as far as the guardian ad litem, is she on the line with us today?
Yes,
Okay.
Your Honor, I'm here.
Okay, great. Thanks. Any concerns if we move it to that date?
No, that will be just fine. Thank you. I appreciate accommodating my timeline.
Yeah, very good. We'll move the Sanchez or Sanderson and Larson matter to March 13th at 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you.
There we have Mr. Vibert representing Mr. Goodfellow. I see that he's present. Mr. Vibert is, and Talon Fleming. Ms. Fleming, are you on the line this morning?
Yes.
Okay, great. I see you there. And I see that Mr. Lawrence is also on the line with us. I show that we're on today for a presentation of from the trial. So I'll just check with the parties. I have proposed orders that were filed and given to the court from Mr. Vibert. And I'll ask if Ms. Fleming, did you receive a copy of those proposed orders?
Yes, I had the findings of fact that was corrected, the corrected parenting plan, and then the original decree.
Okay, great. Those are the 3 documents that I'm also looking at. Do you have any objections or concerns about any of those documents or that which is contained therein?
Yes, I have several concerns. So do you want to go into it now? Or?
Please.
So section 3A of the parenting plan, it was not marked correctly to reflect the October parenting plan that was already signed.
So you're talking section 3A?
Yes, of the parenting plan. So the specifically the section regarding assault on the other parent in nature resulting in pregnancy. That was not marked.
So you're looking on page 2 of the parenting plan, correct?
Sorry, I was seeing emails here. Let me get to the actual PDF. Yes, it'll be page 2, section 3A. So currently marked, it says neither parent has any of these problems. The offense is not applicable since he was not convicted, but the assault should be marked for Eric against me.
Okay.
As well as the neglect that was mentioned in the trial by his own admittance.
Okay.
3B as well.
Let's just take them one by one. So I'll hear from you and then I'll hear from Mr. Vibert.
Okay, sounds good.
So we'll address the 3A, Mr. Vibert.
Good morning, Your Honor. As far as, I mean, the prior order, I don't believe has any bearing on a final parenting plan. According to the court's findings, and I made fairly copious notes as the court was making its findings. I don't believe that there was any findings with regard to any item that would be contained in paragraph 3A as far as limiting factors on the parenting plan. That's why when I prepared the proposed orders, I clicked or I checked that neither parent has any of these problems. Again, I don't believe that the court made any specific findings with regard to that.
Ms. Fleming, do you recall at the trial when the court was making its oral findings or making its oral comments, if there is a specific statement related to that?
No, we did not go over the parenting plan step by step. I do remember the limitations set or the conditional limitations set against Eric, i.e. the parenting classes he needs to take, as well as the drug testing as well, and how that would work. I remember what Mr. Vibert did write down for the supervised contact. That's a later note that I was going to bring up. But as far as going one by one through sections 3A and 3B, we didn't talk about it at all. We also didn't talk about another thing I was going to bring up. But I'll
Okay.
wait for that.
Okay, thanks. So Mr. Lawrence, do you have any input?
No, I remember during my testimony that I did indicate that when it would have constituted assault, but there was no official findings to that effect.
Yeah, I remember something similar, and I also remember when the court was making its oral findings, it didn't address those particular issues. So I'm going to leave 3A marked as neither parent has these problems. And the idea is kind of the ongoing issues. I recognize that much of this order reflects past or historical activity, but I feel comfortable not adding that. So Ms. Fleming, I'm going to leave that as is, and then your next issue.
Next issue was in 3B. Mr. Vibert neglected to mark emotional or physical problem that would hinder Eric's ability to parent. That has been talked about very much so throughout the trial with both his power of attorney, three matters: his power of attorney, his diagnosis, and his treatment plan for that, as well as his power of attorney, his actual diagnosis, and his disability status. Sorry. So I feel like that should be marked. And then again, the aspect of neglect, which we did find in court, at least that is what was my understanding.
Okay, thank you. Mr. Vibert.
Again, Your Honor, and to be brutally honest with the court, I had a difficult time with this part of the order based on the court's oral findings. I understand that the court is wanting limitations as far as getting the visitation started back up, and I did check in as far as paragraph B, lack of emotional ties, to support the supervised visits with the reunification counselor. I don't believe that the court found that there were emotional or physical problems. Yes, he does have a history of mental health issues, but I believe that based on the testimony, and again, I don't think that the court found specifically, but I think based on the testimony, the mental health issues are on a good track. He's got his medications in order and his counseling and so forth. So I don't believe that there were any specific findings with regard to any kind of limitations. So I would leave this one to the court.
Thank you. Under 3B, I'm going to mark emotional, and I'm going to cross out our physical. So I'll add that to 3B. So it'll be emotional problems. This is, again, these are issues that may harm the children's best interest. It was testified that Mr. Goodfellow is doing much better with his mental health, but it's under control now. But there's been times in the past where it's been not under control. So I'll mark those two under 3B, and we'll need to move quickly. So go ahead, Ms.
My
Lemon.
argument was null after that, but for the same section, use of conflict.
I'm not marking that. What's your next concern?
Sounds good. The paragraph with no contact / limited contact, I can look up the exact one here. So it does not detail any of the conditional statements in which Eric will be participating in the reunification therapy. So again, the parenting classes are not listed. The drug testing is not listed. It's very blank. It kind of reads as rewriting history. So I was just uncomfortable with only having the supervised visitation and then the payment for the reunification counselor without those other specific conditions being listed under limitations.
So if on the back of, on the page 13, the second to last page, it talks about modification of the parenting plan once the counselor recommends unsupervised visitation and expansion. And then it talks about provide hair follicle testing and provide release of information from the mental health counselor. So in addition to that, you're indicating what else should be in the parenting plan that's not.
The parenting classes. So
Okay,
I did not see that listed.
okay. Mr. Weber?
Your Honor, the court did not specifically direct parenting classes. I believe the direction was that he were to continue with his counseling and to provide compliance reports to Ms. Fleming.
Mr. Lawrence, do you have any comment?
No, Your Honor, I don't.
But I will point out the testimony was that Mr. Goodfellow is taking a parenting class component in his counseling. But again, I don't believe that the court specifically ordered that.
I don't remember it being.
I was looking back at the minutes from the oral ruling at 2:59. It says court responds. Court notes objection and overrules. Mr. Goodfellow should take parenting class and provide proof of completion. So I'll include that under paragraph
Is that a
14.
continuation of the parenting instruction that he's receiving now, or is there additional classes that the court's wanting him to do? I think we need to
The
get some
oral ruling was
specifics
that
on
he should take the parenting class and provide proof of completion. So if he's enrolled in a class, then he should finish it and then provide proof.
Again, Your Honor, I want to make sure the court is aware. The parenting instruction that he's receiving is through the counselor, his mental health counselor. So it's a parenting component in his mental health counseling. It's not a specific parenting class.
Oh, I see. I see. Yeah, I think it needs to be separate and apart, a separate parenting class that is kind of full bore, full focus on parenting issues. So I'll include that under 15.
Okay, very good.
Thank you.
And Your Honor, one final matter, the non-joint decision-making for moving residencies. That was not listed. We did not get a chance to talk about it because when I received the documents, Mr. Vibert cited the October parenting plan as the signed final version or draft, whatnot. That was talked about with Commissioner Busby as me having or retaining the right as a primary parent to move residencies with Vivian without Eric's permission. I would like that.
It's included under paragraph 13. If you look there, it says moving with the children, relocation. It says anyone with majority or substantial equal residential time who wants to move with the children must notify every person who the court ordered time with the children. If the move is to a different school district, the relocating person must complete the form notice of intent to move with the children and deliver it 60 days before the intended move.
Yes, I did not know if that applied to out of state. So I work in Oregon. And so if I were to move, it would most likely be to Oregon. I did not know if this only covered Washington. So in my specific parenting plan before, I did know out of state. And so that's the point that I'm arguing now.
Okay, yeah, I think paragraph 13 covers that because if there is a move to a different school district, whether it's in state or out of state, then there needs to be notice given as laid out in paragraph 13.
Okay, I didn't know if these specifics only applied, so thank you for the clarification.
Yeah, thanks for raising that. Any other concerns that you have, Ms. Fleming?
No, those are the only points. Mr. Vibert did the other corrections that we spoke about in the email yesterday.
Great, thank you. Mr. Lawrence or Mr. Vibert, any additional concerns that you may have?
Your Honor, I have none.
Okay, all right, thank you. Mr. Vibert?
The remainder of my proposed orders stands as is, Your Honor.
All right, very good. So I've signed off on those 3 orders with those additions that we talked about here this morning. I'll hand those to the clerk and we'll get those filed. And if the parties need a copy of those revised orders, you can certainly contact the clerk's office and get copies of those. Okay, so that'll conclude today's hearing. Thank you all.
Thank you, Your Honor.
we should have Ms. Bliss here representing Michael Bartel. There she is.
Yes, sir.
Welcome. And Mr. Brewer is here representing Ms. Johnson. Ms. Height is here as the guardian. And to the parties, it looks like we had kind of an interim ruling on the 14th of February related to alcohol consumption and corporal punishment. And then we were coming back to hear a little bit more fully about all the other issues on the case. This is my understanding. If I'm in error, please let me know.
I guess two issues that I'd like to bring up for your consideration. First of all, I was away from my office, and when I got back, I saw that I had received a phone text from Brooklyn on the 25th of February that said, "Cody and my mom are fighting." I did not see that until the 26th, so my response to her was, "Are you okay?" By then, of course, at least a whole day had passed, and her response back to me was, "Yeah, that was last night." And I did not follow up further with her. I just wanted the court to know that it's kind of unusual for a child of that age to reach out independently to a guardian ad litem. I don't know any more than that, if she had reached out to others or what went on, but I did think it was important enough for the court to know. And in rereading some of my notes and other things from this case, I'm now considering, as you heard the last time we talked, I think my recommendations may need some adjustment by Your Honor. I believe I may have underestimated the frequency of conflict in the home. And I believe I may have underestimated also the rising level of Brooklyn's anxiety and it seems like her resilience is declining. So in looking over my recommendations, I feel like there's some adjustment may need to be made. I don't know if you want to hear from me now or you want to reserve on that for a few minutes.
I'm happy to hear from you now.
Okay, I was recommending that she be picked up from school on Thursday, and I'm going to continue with that recommendation. It's the second recommendation in my report, but I believe that it would be in her best interest now to go ahead and be picked up after school on Thursday. This is an every other weekend. To have time with mom Thursday afternoon, Thursday night, Friday night, and then to be returned home to her dad at 8 p.m. on Saturday night. I think that would give adequate time, and I think it would also relieve some of the conflict that she has been witness to. So it is a shorter amount of time, but I think it will be adequate for Brooklyn at this time, and I do believe it's in her best interest.
So
that would
your
be my
recommendation is Thursday after school to Saturday at 8 p.m. as opposed to Thursday after school to Monday morning.
Yes.
Okay.
Thank you.
My client was very concerned after reviewing the report of Ms. Height. Obviously, he shared a lot of the concerns regarding Brooklyn's stomach issues, her stressors. He shared that with Ms. Height as well. But to review what Brooklyn's words were to Ms. Height was very concerning. He was unaware of the level of toxicity in mom's home, the threats of the corporal punishment, the drinking, all of those were news to him, and he has some deep concerns about that. In reviewing the declarations provided by mom, some points of concern that I think the court needs to be aware of. Mom attributes Brooklyn's stomach aches to just changing of households. My client wants the court to be aware that the party separated in August of 2018. So this has been ongoing for 4.5 years at this point, and the stomach aches just began by Ms. Height's recollection a few months ago, which from my client's perspective is when the court case began, when the 50-50 parenting plan was essentially put into place. And so my client has some deep concerns regarding Brooklyn's stress and anxiety, which even from the school counselor's perspective occur when she's getting ready to go to mom's. And I think that was pretty consistent in Ms. Height's report and pretty consistent from the counselor's perspective that a lot of Brooklyn's current stressors revolve around her and her visitation with her mother. I agree that Ms. Height's recommendation that Brooklyn seek additional counseling outside of the school is probably appropriate at this time. just to ensure that she's, receiving the right tools and skills to address the stressors that she's experiencing. And I think it'll also provide a little bit more perspective as to the basis for those stressors, if there is something deeper. I found great concern with the fact that mom is diminishing Brooklyn's feelings, and I think that that's a huge point of contention. There is a lot of, from my perspective, reading the report from the guardian ad litem and mom's declarations, there does seem to be a lot of toxicity in the household. Brooklyn expresses fear. She doesn't feel safe with regard to Cody, mom's partner. So I think that those are deeply concerning. And I think that the court absolutely needs to take that into consideration as well. Mom's diminishing of her drinking. Obviously, Your Honor heard perspectives from Miss Height and Brooklyn regarding the measurements of ice. And mom simply states, oh no, I had a mimosa with sparkling cider and I like tomato juice with ice. Obviously that's concerning. So we do want the court to take that into consideration. My request today was going to be that mom have an alcohol abuse evaluation given the allegations of persistent drinking. A lot of Ms. Height's report revolves around domestic violence in all of the relationships that mom has experienced, both with my client and her current. A lot of times those fights are regarding alcohol and occurring when alcohol consumption is occurring. I think obviously the restriction Your Honor put into place at the last hearing of not drinking, either parents not drinking during the time in which Brooklyn is with them will help. But I'm wondering if there's a deeper concern here that needs to be addressed. So my request today is to approve of the guardian ad litem's recommendations. Obviously, she's provided a new recommendation today of Thursday after school to Saturday. I don't know if we want to do that on a trial run to see if that diminishes the issues, or her initial recommendation of Thursday after school to Monday. I haven't had the opportunity, obviously, to discuss the new requested or recommended schedule, with my client. But I don't imagine that he would have an issue with either. He believed that the prior recommendation was appropriate, and then obviously there were some concerns raised after the last oral report and the declarations provided by mother. But at this time, we are asking the court to adopt the guardian ad litem's recommendations, and then additionally making the request that mom undergo an alcohol abuse evaluation.
Great, thank you. Mr. Brewer? I have a note here that says mother's input. Guardian ad litem had only one interview with Brooklyn, not representative. The guardian ad litem report was rushed. Father's employment is sporadic. He lives with his parents. She addresses the mom is not kind comment. Is that the responsive declaration you're addressing?
Yeah, we submitted a supplemental one too that I can. So we submitted that last week, I believe, or actually before that, 2 weeks ago.
Let's see. I read everything up and, when we were here last, I was up to speed, and then I looked at the most recent filings and I read those. There was a report or a declaration that was signed on February 8th and filed on February 14th. I read that. And then on the 24th, which on the 24th, I read her declaration that was stated on February 17th. So I think
Perfect. Thank you. Well, my response is I'm kind of troubled by how this keeps unfolding. We had the report, the guardian ad litem orally at the last hearing brought new information. I haven't seen a follow-up supplemental report from her on that we've had to respond to. And then today, I get another kind of off-the-cuff comment, and it's remarkable to me that a text from the 9-year-old to the GAL unresponded to or not followed up further has resulted in her rethinking her recommendation to take another night away from my client. I'm concerned that we have a situation which is not uncommon here, where we have a 9-year-old or a child that kind of knows the situation and knows how to play off people. And I'm concerned that that's not being followed through carefully, because my client doesn't diminish these things. My client denies these things. Everyone keeps, or the guardian ad litem and counsel speaks of alcohol. There's no, these cases I deal with, there's no evidence of rampant alcohol abuse. There's a contention that there was a mimosa. Since when does that rise to a level of everyone having deep concerns about alcohol abuse by my client? There's no other evidence on that topic. Ice in a freezer does not an alcohol problem make, and I don't think my client spoke to that too. She didn't diminish it. She explained it. She didn't diminish the issue of the coffee incident. She explained it. And again, you have on one hand the 9-year-old asking for a drink from the red leaf coffee situation, and then the other hand telling the guardian ad litem she's in fear of her mom leaving to the gym. So there's some disconnect going on here that I'm concerned is all falling on the side of the ledger of my client unfairly, and I think it warrants deeper investigation. Our comment about kind of the superficial investigation comes from the fact that this started in October, and before last hearing, days before, is the first meeting that was had with the child, as I understand it, and it happened at school, and then we had the day of a follow-up in response to that. So I'm just concerned that we're getting lost in what is really happening as it relates to this child. I'm concerned about imposing a schedule. It's not true that these folks have had a 50-50 since 2018. I mean, my client was primary when it started, and the 50-50 only occurred more recently. So to diminish her time based on allegations, including the other thing that troubles me is the discussion of abusive relationships. There's no evidence of, I think counsel said, all of her relationships. There's no evidence of multiple relationships of abuse. There's no criminal matters pending. The issue raised against her current person there was from, what, 5 years ago. There's no discussion of Mr. Bartel's past history of criminal matters or abusive matters. And there's really no evidence of abusive relationships apart from yelling and screaming. So I understand their concerns. I think they warrant further investigation. I just don't think they should result in a pretty severe and significant cutback on my client's time with the child. This matter should proceed to trial because my client looks forward to having that day in court to unravel these things. But for the moment, I ask the court not to adopt that and to maintain the schedule. She's under the microscope, so she should be on notice, and that will help hopefully alleviate some of these concerns that are happening as the child is reporting. So thank you.
Thank you. Okay. All right. So I think first off, the concerns of that Brooklyn's, her stomach aches and the nail biting are manifestations that she's under a lot of stress and she's suffering quite a bit. And the exact source of that nail biting and the stomach aches is uncertain. There's several possible explanations. One could be the current stress of the litigation. I recognize they've been separated for quite a period of time. I also recognize that Mr. Foster is relatively new to the relation to the family, having moved in, I think, around October of 2021, so roughly a year and a half. So there's probably a combination of all of those different things, but obviously the concern is that she's suffering and she's having a really hard time. So absolutely immediate counselor outside of school for young Brooklyn, and a minimum of 3 months, and probably longer, depending on what the counselor thinks, but a minimum of 3 months. I think that's a great recommendation. I think all parties would be happy to support that. The father will be the primary custodial parent, and I think joint decision making is appropriate for all areas. As far as the mother's time, the concern raised today is that, and it's not a new concern, is that there's arguing and disputes being heard, or Brooklyn's been exposed to those with mom and Mr. Foster. And that's a frightening thing, scary thing for little people to hear adults get after each other. And so there's added concern raised by Ms. Height today that highlights that. So I think that we previously indicated that there should be no alcohol consumption 8 hours prior and during residential time. That'll continue. No corporal punishment. That'll continue. No threats of corporal punishment. That'll continue and be incorporated in this order. It's interesting. I recognize Mr. Foster. There's some issues there where he indicated that there was no weapon involved in this May 2019. I recognize it. It's dated. And yet at the same time, a dated occurrence continues to have some relevance when it's not represented accurately. When he indicates that there is no weapon involved, and the police reports indicated actually he pulled a gun and pointed at somebody with a round in the chamber. Significantly different versions of what's happening. So there's an effort to downplay the seriousness of that. So there's a recommendation that the time should be limited with the mother. And part of that limitation request takes into account Mr. Foster's role in the family. There's arguing that does occur, and not to say that doesn't happen in many relationships, but in part it's having a negative impact on Brooklyn. So at this point, I'm going to adopt in part the revised recommendation of Ms. Height. The Thursday after school time for the mother on the first, third, and fifth weekends, as defined by Fridays, will stand as the start time for mother. And then I'm going to adjust it a little bit to Sunday at 7 p.m. and leave that for this time period. And we'll take a look. The counselor's going to be involved, and hopefully they'll provide extra support for Brooklyn. And if the timeframes of visits become an issue, I think we'll probably hear about it, because Brooklyn is not a shy girl. So with that, I think the limitation and restriction that Mr. Foster or Ms. Brooklyn, little Miss Brooklyn, is not to be left alone with Cody Foster. That should be part of the temporary order, that in no circumstances would she to be left alone with Mr. Foster. The phone for the child, the recommendation there's been some issues. It sounds like the rules are hopefully more clarified on each family. But the rules about those phones, phone for the child should be known, and the child should have opportunity with reasonable rules to use that phone to reach out to the other parent. That's kind of squishy. I recognize that, because it's somewhat difficult to get precise with different home rules. As far as UAs, the father indicates that he's in his current employment. I think it's at Hanford, that he's regularly drug tested and the like. If he leaves his current employment and is either unemployed or takes a new job, then the mother can request a UA, and he would need to take that within 4 hours. The indication, as far as the concern raised, as far as the way Brooklyn measures alcohol consumption in her kind of childlike way, is via ice consumption. And that may be accurate, may not be very accurate. It could be a tomato juice, it could be mimosas, I don't know, it could be a lot of different things. So I think there's enough there with what's going on with the conflict and some showing of alcohol consumption. I don't know if it's too much or not, but kind of prudence tells me substance use disorder evaluation for the mother would be prudent. If there's no issues, then the experts will tell us there are no issues there. Parties have been separated for quite some time, so I'm not sure collateral input from Mr. Bartel would be helpful. And certainly Ms. Height could chime in and have collateral contact if the evaluator is interested in that. So let me just take a look if there's other items that I had missed. Yeah, the disparaging comments within earshot of the child, obviously that's a part and should be included within the temporary order. Other than that, I didn't have any other specific notes that I was going to make a ruling on. So if the parties, if I've missed something, please point it out and we can address it.
Your Honor, just to clarify, on the weekends, were those determined by the Thursday or by the Friday?
Probably better to do it by Thursday. Yeah.
Thank you.
Thank you. Let's make that change to the first, third, and fifth weekends as determined by the Thursday. Thank you.
Thank you, Your Honor.
Ms. Bliss, Mr. Brewer.
I didn't have anything else, Your Honor. Thank you.
Nothing further.
Okay. Presentation of that order in 2 weeks if the parties don't come to an agreement with the presentation.
That should be fine.
Yeah, that's fine.
14th of March for presentation. We'll see everybody then. Thank you. Let's take the Williams and Williams matter. 19-3-154-08 is the cause number. There we have Ms. Jocelyn representing Sarah Williams as Ms. Radecki representing Mr. Williams. I see Ms. Jocelyn is on the line. I see Ms. Radecki is also on the line. And we are on today for a presentation of an order. So let me just touch base with the parties. If I don't have any. Yep, I do have a proposed orders here, and they were submitted by Ms. Radecki. And I'll ask Ms. Jocelyn if you received a copy of those proposed orders.
We did, Your Honor, but we prepared the orders and sent them up to you last week. And so I had asked Ms. Radecki that we go off those. I have not had a chance to review her orders. I don't have any idea what they say. So if we wanted to recall this, I could email them to the JA, but we sent them up with our bench copy letter.
You said that was last week.
Yes.
So I don't have them in my possession, so I'm not sure exactly where they are at this point. If the parties want to proceed, we could probably handle it today if you wanted to email those directly to me, and then I'll pull up on my screen and I can take a look at it and we can review it later on in the docket.
Yes, Your Honor. I will send those to you right now with a copy to Ms. Radecki.
Okay. And do you have my email address?
I do not. I was going to obtain it offline if you didn't want to announce it over air.
It's publicly available. It's cowlitz.wa.gov. So cowlitzwa.gov.
Perfect. I will go ahead and send those over to you right now, Your Honor.
Ms. Radecki, any concerns if we proceed in that fashion?
That's fine with me.
Okay, great. And then Ms. Joslin, your CC State, and she is on the line. I see her, and Ms. Gravina is the guardian ad litem, and she's on the line too. So we're on today for input from the Reunification Counselor on how to move forward. And I didn't see any updates, and I'll just check with the parties if you've seen anything or if I've missed something.
Tanea Gravina, guardian ad litem here, Your Honor. I have confirmed that the parties have paid and the process is moving, although I don't have any updated recommendation or request from her yet. I got confirmation that the parties have paid about a week and a half ago.
Meaning they paid the Reunification Counselor?
Yes. So the process is moving forward. I just don't have any, she has not given me any updated recommendation or requests that she needs. I do have follow-ups to her just to see if there's anything else that has come up in the last week and a half, 2 weeks. But I have not heard back from her yet as far as that part goes.
Okay, so you don't have any knowledge that the Reunification Counseling or any efforts of meetings, sessions have happened yet?
My understanding is they're scheduled, but my understanding of her process when I spoke with her was that she likes to get a baseline for each of the parents and the child first, and kind of have a couple of meetings with them to see how comfortable and how best to proceed forward with things. And then she will arrange the first meeting like with the child and the parent. And so typically my understanding of her process is she does take the time to get kind of a baseline established for each of the parents and the child first.
Okay. Any Ms. Gravina, do you have any estimate as far as timeframes with that counselor of when it might be a good time to review the case?
Your Honor, I actually have an update if you want to hear that.
Yeah,
okay.
Sure. Go ahead, Ms. Oak.
My client, Jake Swingle, indicated that he's met with her. I believe they've agreed to the 50-50 split on the rates. The daughter has written a letter and a picture to my client with Ms. Long, and she scheduled a video call this Friday, March 3rd, to start things off. But I think things are moving well. Mr. Zandy and I have discussed it, and my understanding is that we would just have the clients continue to cooperate with Ms. Long and then review this along the way. It's a bit of time from now, 60 days or whatever, see how they're doing with it. But it seems like the cooperation is there and there's finally some movement. So that's a good thing.
Thank you, Ms. Oak. Mr. Sandy.
Yeah, I do appreciate my communications with Ms. Hoke. I've also spoken to Ms. Long a handful of times, as has my client. I don't know where this is all going to lead us and in what direction, but I think the important thing is that Ms. Long has been proactive in getting out in front of it. I know my client has spoken with her. I understand after my conversations with Ms. Hope that Mr. Swingle has too. And again, I don't know where this puts us long term, but I think the positive aspect of this is that everybody's on board with Ms. Long. I think she's doing her due diligence to get whatever she finds necessary. That is in the infant stages, and that has occurred. So I think that's a positive step. This case has been review after review after review over the past several months, at least since my involvement since the fall. I think everybody's on board with just getting some direction on this, and I think Ms. Long is taking the steps to provide that. So I think that's encouraging. To answer your question of when an anticipated review should be, I don't have the answer to that specifically. As the court's aware, these reunification cases are a very individual case-by-case basis, and it's hard to predict where we go with that. There are issues that the child has had over the past several months, again, since my involvement in times of meeting with dad and counseling and such. I don't know that we necessarily set one, and if we do, I think it needs to be 60 to 90 days out, because this does cost everybody money coming back and essentially spinning wheels. So I do think the positive from this is that Ms. Long is involved, and she is, as she typically does, upfront with things and is getting things processed. I think that's good. But as far as the review date, I'll leave that to the court's discretion as to when you want us back. We'll be here hopefully with some more information.
Thank you. Ms. Looney, do you have any? Oh, I just want to check, Ms. Looney, do you have any comments?
No, Your Honor.
Ms. Gravina?
One thing that Allison and I or Miss Long and I have discussed and have utilized on previous cases was setting kind of a parameter where we would review if it gets up to a certain point. In previous times, I think she has kind of been super comfortable about if the visits should, or she would recommend them progressing to where more than 50 or 75% of the visit could take place outside of her facilitation, then she would make that recommendation and we could bring it in for a review at that. Would that be a reasonable concession? Is that if it gets to a point where Miss Long thinks that it should progress past that point, then we can note it up?
But I don't know that we're at that point yet. That's kind of where we're at, is figuring out if visits are appropriate, if that's in the best interest of the child. And we don't have that yet. That's part of what we're doing with Miss Long. So I'm kind of the opinion that we just kind of put it in Miss Long's capable hands to see where we go from here. And if visits are recommended, we'll evaluate it and we'll go from there. If they're not, then we'll again kind of decide from there and make some concessions. But I don't think we're at the point now where anticipating what is or is not going to happen is going to be a worthy exercise at this point.
Yeah,
Okay.
I know my
Understood.
client would prefer a date certain, Your Honor, for review.
Ms. Hoke, what was that you said about a date certain?
Well, I said my client, I'm sure, would prefer a date certain for review rather than waiting till some possible point in the reunification.
Okay. I appreciate everybody's input. Reunification counseling is a creature unto itself, and there's 4 individuals that are involved, and it's really hard to predict where we're going to go. I'm going to set a May 30th review. That's 90 days. And if there's any big concerns before that time, obviously the parties can come forward. I'm sensitive to the bill that clients incur with regular reviews. So May 30th, I think that'll be far enough out, hopefully, that there'll be some progress, and that limits coming back to court with any frequency. And obviously the court parties can come back to court if there's any big issues.
Thank you, Your Honor.
Okay, on the Williams matter, going back to that, I have both documents up before me. And I'll just see if Ms. Jocelyn and Ms. Radecki, yep, you're still here with me. That's a good sign. So I have proposed parenting plans and temporary family law orders that are here before me, each from each respective party.
I think it might be easier, Your Honor, and I apologize. I had asked Ms. Radecki if we can go through ours, because she had written us objections. And then when she sent us her proposed orders yesterday, I haven't had a chance to review them. So it might be easier just to go off ours since everybody has reviewed that one. And go
Okay.
through her objections.
Ms. Radecki, are you comfortable with that?
I will just say that even the altered version that just sent by Ms. Jocelyn still did not include my objections. So I think that it would probably be more appropriate to go just line by line in the things that we dispute, and then whichever order has the governing language just to proceed on that more route.
As far as like the level of disagreement, is it, you'd say there's between 0 to 5 areas of points of disagreement, 10, 5 to 20, we're kind of where we're at. Because if it's a larger number, my inclination would be to allow the parties to look at this offline, talk about it, and there may be some resolution on a great majority of the issues, and there may be a few sticking points. So maybe you can give me just a bit of guidance of what level of concerns there are with the competing orders.
Your Honor, there's Ms. Radecki sent me 6 objections. There she has 1 objection to the family law order, and then 1, 2, 3, 4, 5 objections to the parenting plan.
Okay. I think we can handle that today. So let's take up the temporary family law order. That's the 3-page document. Page 1, I'm assuming there are no issues on page 1?
No, Your Honor, her objection was to section 8.
Yes, that's accurate.
Section
Number 2.
8, item 2.
Okay. Ms. Radecki, if you want to go ahead and share your concerns.
Yes, Your Honor, thank you. I just had an issue with the wording of Ms. Jocelyn's section, because she framed it as progress as far as his risk with Dustin. I had reviewed the tape of your oral ruling back 2 weeks ago and had drafted my section to comport with your actual words used. So I think it's a more appropriate wording of what your oral ruling was. It was the progress in therapy, wasn't specific to the risk with Dustin.
Okay, thank you. Ms. Jocelyn.
In Your Honor, I did take notes. You did specifically say you wanted to know what the progress was in terms of his risk. That word was used. And then we started off like not talking about reunification, then you circled back to it when I had asked if you were ordering. The court had specifically stated that they're going to rely upon the counselor. Like if the counselor recommends, let's do reunification, great. If Ms. Radecki doesn't want to put that in, that's fine. But to me, that just simply delays Dustin's reunification, because the therapist recommends in 2 weeks, let's start reunification. He's not waiting till May to start it.
I will make a brief comment on the reunification part. My proposed order, and I know Ms. Johnson said she hasn't had a chance to review it. We do believe that the reunification therapy should be commenced immediately because it was recommended by the therapist. So we would be requesting that start, I mean, if even early as next week.
Okay. Thanks. Let me just take a moment to look at these side by side. I mean, they're fairly similar, but there are some key differences that you both pointed out. So let me just take a quick look. Okay. I recognize there's some emphasis placed on the risk. And I'm also cognizant of the importance of that reunification counseling starting sooner rather than later. So I'm going to adopt the language in Ms. Radecki's proposed order on the temporary family law order. So I'll sign off on that. And then we'll next turn to the parenting plans that each party has submitted. So I'm not sure if Ms. Radecki, if you want to address looking at your order or looking at Ms. Jocelyn's order. I think on the last one, we were taking a look at Ms. Jocelyn's order as kind of so however you want to approach it, we can address it however you want to look at it.
Yeah, and I can just mention the section and then mention what the differences are, what my position is. I think that would probably be best. For section 3A, I know the court declined to enter into any of the 191 factors during the ruling 2 weeks ago. We would be requesting that his name gets taken off. There was no determination of anything regarding to Dustin at the hearing 2 weeks ago. So I believe that just leaving it as reserved is more appropriate than having it as reserved as to Dustin Williams, because that indicates that the court is more likely to enter into those factors against Mr.
And
Williams.
Your Honor, the court was specific. The only person who has 191s potentially is Dustin. So this is how it's frequently been, where we just put reserved as to. There wasn't a request for those 191s against Sarah. If there was, I can understand that, but we don't want the implication that there is a potential for her. Because they did not request that. So it specifically was, we had these, 6 factors, and he specifically said reserved as to Dustin.
I'm going to opt for the reserved as to Dustin Williams language. So I will include that. All right, and then Ms. Radecki.
Let's see here. Next, section 4, the limitations. I did just want to actually bring something to the court's attention. I know that at the oral hearing that the court ordered, either the maternal grandparents or a professional supervisor supervise. I was informed by counsel the day after that ruling that the maternal grandparents no longer are willing to supervise. And so that puts Dustin in a position where he's forced to pay for a professional supervisor, and he's done so to exercise his parenting time. I don't believe that that is fair. He's also proposed, let's see, 6 of his own different, let me see, 1, 2, 3, yeah, 6 of his own non-professional supervisors. And I do believe that if Ms. Williams has an objection to all of those supervisors, that she would be responsible for paying for the cost of professional supervisor, because right now we're putting in a position where he is forced to get a professional supervisor, which is not fair.
Okay,
We can respond, Your Honor.
yes, go ahead, please.
So the court was very specific. It was her parents or professional. There was no request that she pay. This conduct is due to Dustin. This is nothing that Sarah did. Additionally, I know Your Honor and opposing were not part of the prior DVPO hearing, but in our prior TVPO hearing, Dustin specifically requested a professional supervisor. We have given reasons as to why we do not agree to his fiance's family, such as his fiance's family are not responsible. They have criminal records, such as being a felon. And also, I did not send this to Ms. Radecki yet, because I just received it. So this is not supposed to be some like ambush, but I literally just got an email from the therapist, which I can send to counsel and court, that says the therapist does not agree whatsoever to use anyone from his family or any of his friends, particularly a convicted felon, because it negates the purpose of having a neutral third party. So if we need to adjust times, I know that my client has since talked to one of her friends, and she is on the line, and she can let you know her friend's willing to do some weekend visits as long as they occur in Clark County. I think her parents might be willing to do like 1 weekend a month. So I think we're really talking about 1 or 2 weekends in a Wednesday visit.
Okay.
And
all
my
right,
client could come on the line and give the name of her third
So
party friend.
let me ask, Ms. Radecki, you have 8 individuals listed here. Obviously, the MedVeds they've indicated that they're not interested in providing that supervision. And then there's 6 other individuals here. The Whites, there's 3 Whites, and then 4, and the Ms. Schmidt and Mr. Belt. So the amount of time we're looking at here for father's visitations are first, third, and fifth weekends, Saturday noon to 4 p.m. So 4-hour stint, and then a Sunday, another 4-hour stint, and then the Wednesday visit. Paying for visitation can be super expensive, and here we're looking at in 1 week you could potentially have, or potentially, I guess, 8 hours, depending on how when school gets out on Wednesday, if it's early release or not. So that certainly can be cost prohibitive. On the other hand, then, you know, the grandparents, they were people that were known to the child and were comfortable with the child. So that makes sense that they would have been approved. I guess what I'm leaning towards is a professional supervisor or an agreed upon supervisor that's not unreasonably denied. You know, if there's a criminal history with somebody that's relevant to child safety, that might be a reason to deny, a reasonable reason. Other than, you know, personal dislike of a person, probably not solid grounds. So I think somebody that can pass a criminal background check, relevant. You know, if somebody's been convicted of a theft in the 3rd degree, probably not very relevant. But it could be, I guess. But so I think that's what I'll go for, is that it'll be professionally supervised or an agreed upon supervisor with not unreasonably denying a supervisor. So for example, if Mr. Mr. Williams proposes one of those 6 individuals there, and there's not one of those would have to be agreed upon if there are reasonable grounds. It could not be denied if there were reasonable grounds not to deny them. So that's kind of negative speak, but I think hopefully I got my message across.
Yes, Your Honor.
Yes, Your Honor. And I know that this might be a moot point, but I just wanted to bring it up for the record. Let's see here on that section 4 at the very bottom too. Council put that my client is to follow all recommendations by the Battleground Municipal Court. Frankly, that's completely different jurisdiction and not relevant. The court, I believe that it should be removed from section 4.
Follow all recommendations by Battleground Municipal Court and follow any and all conditions of his criminal case. And in addition, be evaluated for DV. So, okay, thank you, Ms. Jocelyn.
Yes, Your Honor. The court did state to make sure to follow all their recommendations. And I don't know if that was colloquial in terms of getting to the DV evaluation. You know, we need to ensure he follows all recommendation. We're going to order a DV. So, I mean, it doesn't matter to me if it's in there because he still has to follow all the recommendations from the criminal court. So either in or out, as long as the evaluation part stays in.
Okay. Yeah, I think I'll omit on page 2 that section that says Dustin to follow all recommendations of the Battleground Municipal Court. So those 2 lines there, I'll omit that and just leave the domestic violence because I'll allow that court to do what it does, and I'm sure they'll follow through. But the requirement, I think that both parties indicated here, is that their domestic violence evaluation for Dustin be completed.
We'll just make a clarifying note about the domestic violence evaluation. I know that Ms. Jocelyn indicated in her proposed parenting plan that he's to start and comply with treatment. If Your Honor would like that to be a part, then that would obviously be, I'd have no objection to that. But the court did specifically mention that it was just an evaluation that needed to be completed. So I just wanted to make a note of that as well.
Yeah, and I guess I mean, start if the domestic violence evaluation says that there's no treatment needed, then they've started and finished before they even got started, I guess. And if there is, you know, a class that they recommend or something more extensive, then starting and complying with that treatment, I think that's okay. So I think that's okay to leave in. I don't think that really negatively impacts anybody one way or the other.
Time schedule. Under the limited schedule only, I just would note that the distinction is that the no contact right now is due to the protection, the DVPO that expires June 6th. I worry that, you know, if this temporary parenting plan is still in effect past that June date, that'll restrict or have some issues with the contact. Or I just want to make a note to the court that it's not Dustin abandoning his child. The no contact is due to the DVPO.
And
okay, so your proposed, are you adding language, deleting language? Tell me what you're thinking.
I just wanted to add, in section 4, only due to a DVPO expiring June 6th, 2023.
Okay.
And if we can be heard, Your Honor, that's just standard language that's on the form. What that's saying is instead of filling out sections 8, 9, 10, and 11, we're just filling out section 4. The no contact isn't a restriction. It's saying that there's no visits except for what's listed in section 4. It's standard language on the form. We didn't change anything.
Okay, so here, Ms. Jocelyn proposes language: children shall live with Sarah Williams and have no contact with the other parent except as described in section 4. Section 4 is the supervised visitation and gives the weekend time and the midweek time. And then Ms. Radecki indicates there on her proposed, the children shall live with Sarah Williams and have no contact with the other parent except as described in section 4, only due to a domestic violence protection order expiring June 6, 2023. So what that's saying is that that Mr. Williams isn't to have any contact with the children because there's a no contact order in place that's going to expire in June. So June 6 comes around and there's an expiration of that order, we'll assume. Then there's kind of an opening made, if you will, that allows Mr. Williams to come open the door a bit, because the reason for that limitation or limited schedule was because of the domestic violence protection order. I think that's, I'll decline that invitation, because I think that that's not just that domestic violence protection order. There's a host of other things that go into that determination. So I'll opt to use the language provided in Ms. Jocelyn's order. So let me just get there to that page 4, just one quick second.
I believe she has one more, Your Honor, and it's agreed, section 5B, reasons for limiting decision-making. The box where it says major decision must be limited because the problem in 3A, I'm fine putting reserved since we haven't determined 191s yet.
Okay. Ms. Radecki.
Yeah, that provision is agreed. I do have just another thing on the final page of the parenting plan though as well. 7 of the parenting plan, section 14. I will note Ms. Jocelyn's proposed order states there shall be no phone call between Dustin and the minor child. That is redundant. There is an existing DVPO, and I don't believe it needs to be included.
And Your Honor, that you were very specific when you were going through your ruling, because we had talked about visits, we talked about phone calls, because throughout the DVPO, he was given 2 phone calls a week. Ms. Radecki asked about phone calls, and Your Honor said no, based on the amount of visits that he had already. So that was an order. It needs to be in there because also in the prior DVPO, he was allowed. So we don't want anything conflicting. You know, Dustin unfortunately has been pushing the limits and pushing past. So we want to be just very clear what the parameters are. This is a temporary order. If at some point in time, the therapist recommends that they have phone calls, we are all supposed to follow the recommendations of the therapist. But it was very specific because counsel had asked for that and the court said no.
All right. I'm going to decline the invitation to remove the 14 sub 1, and I'll keep there shall be no phone calls between Dustin and the minor child in this
I
temporary
think
order.
that is all that I have. I just have 2 clarifying questions for the court.
Okay, go ahead, please.
Regarding the child development class, what is the time frame? It would be a 4-hour course be sufficient for the court?
You know, that's a really good question. There's an array of child developmental classes out there. I'm really not up to speed of what the full offerings are, how many hours they are. You know, some classes you can sit through a video and sleep and get credit. Others you have to be more interactive and actually think. And so I'm open for suggestions from the parties, but the court's concern is to give the father some added tools and understanding of the child's development so that he can be a better parent. And so anything that moves towards that end is what the court's looking at. So if you have any suggestions from the parties, I'm open.
Your Honor, we would just suggest that he participate in one, or if Mr. Decky wants to send one. It looks like Incredible Years is more than just a 1 4-hour class. So what we don't want to do is have him find the least amount that I need to do. The point is what class offers these tools? Is it an 8-hour class? Is it 2 4 hours? It needs to be something that the court was very specific. It said such as Incredible Years, implying it should be Incredible Years or something similar to that. Not how do we get out of this in the shortest amount of time. It's how do we learn the tools?
I will just say, I think that is completely mischaracterizing my concern. I know that the Incredible Years is quite a costly class. So given, you know, all these expenses with having to take on a professional supervisor and pay for that, my client is just trying to manage finances right now. And that's really where the concern comes from. It's not trying to get out of the lowest amount of classes possible. That's not the correct characterization.
Mr. Decker, do you have an idea of the cost for that, the Incredible Years?
The one that I was looking at is around $550 for the course, and that is quite a price, high price in my opinion. And I know that when Your Honor orally ruled a couple weeks ago that incredible years could be an option. I just wanted to clarify to make sure that the course that he was enrolling for met the qualifications of the court and would be accepted by the court. So that was my.
Do you have an estimate, Ms. Radecki, as far as the time it takes to complete that particular $550 course?
I do not, Your Honor. I think it's several different days. I don't have the actual hours in front of me.
So I think at least for most learners, being exposed to a particular topic for a longer period of time generally allows more receptors to capture information, and hopefully that gets into a person's system and mind and psyche and heart and makes a difference in behavior. That's I think, you take a one seminar on a particular class or a particular topic and it's like, oh, that's really interesting. But then if you take, a full semester worth of a topic, obviously it sinks in a lot deeper and there's a lot more depth covered. I'm sensitive to the cost. There's a lot of costs here for Mr. Williams. And I think that Incredible Years will provide some significant, I've heard good things about it. I've never taken it. I've never looked over the curriculum. I've just heard anecdotal input from parties who have taken it. So I will require it, notwithstanding the not insignificant cost.
And Your Honor, we're fine if it's just done sometime before a review hearing. We're not asking that it's done tomorrow. So we're looking at, 3 months until our next hearing. And if he needs additional time, that would just go into, I guess, request to expand his time.
Yeah, I mean, certainly that's if as he completes that certainly provides a good footing for a request for additional time. The general idea is there. It's, I don't know how long the course is, like we talked about before, but the sooner that information can be digested and put into play, the better. So I think I'll just add should language, not a shall, should be completed within 150 days.
So the court is ordering Incredible Years rather than another parenting or another child development class?
Yeah, not hearing a reasonable alternative, because I think it's just a 4-hour class. I think that's at least in my estimation, gives a nice taste, gives an exposure to a particular topic, and I think revisited on multiple days would be helpful to get that information deeper into a person's. Has a greater potential for transformation and change.
Totally understand. I will say the class he was looking at already online, they do have like a wide variety of classes or of length between like 4 hours and I think it's like in the 60 some hours. So that's why I was kind of just trying to whittle down the hour because that is a more affordable option.
So that Incredible Years ranges in hours from say 5 to 60?
I mean, I do think that the Incredible Years, based on my limited research of it, is like a multiple week class. Like I think it's like several 8 weeks. I mean, I need to look into that to verify that, but I do think it's quite a lengthy time commitment. I understand that the more Dustin is exposed to the class, the better. So I can look into that though.
So I think that I don't want to mandate one particular class. I think more than a few hours. I think multiple sessions are important. So I guess I won't add specific Incredible Years. That could be simply as an example, as it's kind of suggested here, such as Incredible Years, and it may be something with multiple sessions spanning. I don't know. It's hard to say. Multiple sessions. I think multiple sessions will be good.
Okay. That works. Quick things just to clarify. The reunification therapy, since it was recommended by the counselor, Dustin would like to begin that like immediately, like starting ideally next week. Is the court adverse to ruling that as well right now? So
when it starts?
Yes.
Yeah, I don't, I'm really deferring to the experts, the reunification counselors, their expertise. If they feel that should start today at 2 p.m., then it starts today at 2 p.m. If they recommendation otherwise, then I would defer to that expertise.
Okay. I will reach out to
Your Honor.
Opposing counsel to get that resolved. Just again, sorry to clarify, the cost of the supervisor. So if Ms. Williams refuses every non-professional supervisor, will she be responsible for the cost?
If it's unreasonably denied, yes.
Okay,
It's reasonably denied, then no.
okay, understood. That is all from me. Thank you.
Ms. Jocelyn?
No,
Additional-
thank you, Your Honor. If Ms. Radecki can send us whomever her proposed supervisors are outside of what the family was, and because the therapist does not recommend that, then we'd be happy to review those, and we will send over our proposal as well.
I don't know. I mean, again, I think that the fact that I haven't seen the therapist saying that she doesn't recommend being around the family. I mean, Silas is familiar with everyone that has mentioned in my proposed parenting plan as far as the non-professional supervisors. So I don't think that that is a reasonable basis to reject all of them outright, all 5 of them.
Your Honor, if we're following the recommendation of the therapist who has the child's mental health in mind, and we have very specific reasons such as a felon, I think we just take it up with Ms. Radecki. I'll send her an email, let her know why we refuse, and if she has an issue with it, she can bring it back. But, I think the parties really do need to follow the therapist's recommendation.
I think all those things go into whether a person reasonably denies or unreasonably denies a particular supervisor. So obviously reasonable is kind of a squishy word. And so I'll allow that. As far as the language in the order, I think that we'll use that language that it'll be a professional supervisor. And if that's not desired because of cost or what have you, then it can be a lay supervisor that's agreed upon the parties, not unreasonably denied. We've gone over several points. I've taken notes. I assume that you all have taken notes also. As far as those revisions, I can do those. I don't have working papers. I have 2 separate, hard copy and a PDF. I think it would be, I'm making this assumption, it would be easier for one of the parties who has the working documents in a Word format to create, make those adjustments on the things that we talked about here today. Would one party be willing to take the lead on that, or both?
And we don't mind, Your Honor. I think you indicated you were going to take Ms. Radecki's temporary, so we're fine with you signing that. And then the couple of changes Ms. Radecki requested and granted were minimal. It was, you're not removing the reserved as 191s. You're crossing out one line under section 4. You're not removing the phone calls, and we're adding the words not unreasonably. If there's any way that you could possibly interlineate just so the parties have a complete order and we don't need to come back, because I don't think either party has the funds in which to do that.
I'm sensitive to that. So I guess what I could do is print off this hard copy of the document submitted by Ms. Jocelyn, interlineate based on what we've talked about here today. And then I will send a copy to the parties.
I think that works.
So I'll put my notes here, and then I'll do that after the docket. 22355608.
Okay, thank you, Your Honor.
It's on today
Thank
for
you, Your Honor.
temporary orders. Mr. Fuel is here representing Mr. Johnston. I don't see Ms. Jennifer Johnston. Jennifer Johnston, are you on the line today? If you are, please make sure you're unmuted and state your name. Jennifer Johnston. We were here a little bit ago and we set it over to, we were on the February 21st and we set it over to today. And all the notice shows that the hearing was set for the 21st. That's the day where Mr. Fuel was here, Ms. Johnston was not here. And so just keep looking for an update from Mr. Fuel, because it was kind of vague as to the reason why we set it over last week. And so I'll just turn to you if you have any new information you want to share.
Yeah, I don't, other than I still have not heard anything from respondent. No attorney has contacted me. I haven't seen any filings. Obviously, I think the court has the same vacuum of information. I know that as the court may or may not recall, last week we had appeared, and the timeline was close enough that it was, good faith reason to, set this thing out another week to see if if respondent would file any sort of appearance of any kind. At this point, I haven't seen anything. I haven't heard anything. My client, there's a protective order between the parties, so he has not had any contact with his wife. And so at this point, Your Honor, again, I don't know what the normal practice is in your county on your docket for situations like this. I did file a proposed parenting plan. We would ask the court to adopt that. At this point, I don't have any information about mom's finances, and so I would ask the court, I guess, to reserve on support. My client has no problem doing that, and it's my understanding that he is contributing to the community expenses right now. For whatever it's worth, I understand. I've reviewed the existing protective order, and it does allow. I think the specific language is something to the effect of parenting time per whatever the this court determines as far as a temporary parenting plan in the family law portion of this case. So we can adopt a parenting plan and not have it be in violation of the protective order. Again, under normal circumstances, I'd ask for some fees. We did ask for that in our motion, although I left it to be determined, again, because I haven't seen any financial information from the other side. My client does indicate that she receives approximately $2,000 a month between some different sources of federal help. They're both veterans, and I believe that they have 2 adopted children, and so they receive some money in that capacity. So again, I guess probably the most reasonable thing to do if the court's going to take some action today would be to, I guess, reserve on fees as well. I would point out, of course, as the court knows, we've appeared a couple times in this matter, and mom has failed to do anything. And I guess the last piece of specific relief we put in our motion was a pretty limited restraining order language, just the do not disturb. I had anticipated that there would be obviously an appearance by mom, and there might be some issues as far as contact issues. At this point, it's probably also unnecessary, since the parties at this point aren't having any kind of contact because of the DVPO. And again, I appreciate that only goes one direction, but and quite honestly, Your Honor, I don't know how the practicalities of a parenting plan being ordered without mom engaging in the case. I imagine this will be a pretty arduous task to get this moving anyway. All that said, without anything else being presented today, I think that our position solidly is simply that the court orders our proposed parenting plan, and I guess just reserves on the rest of the requests for action. That's all.
Thanks, Mr. Fuel. Well, it's interesting. Mr. Johnston's declaration is one of the more interesting declarations I've read in quite some time. It really is. There's indications that both mother and father are suffering from mental health issues, and it sounds like they're hopefully getting treatment and continuing with that treatment. The issues from November 2022 are very concerning, related to suicidal threats, self-harm, inpatient treatment for 2 weeks, outpatient treatment for 8 weeks thereafter, indications that the mother is struggling with her own mental health issues. And I'm kind of flying into this blind because, I have information from Mr. Johnston, which frankly is concerning to me, about his stability and ability to be with the children and care for them in an appropriate, safe way. And then I also have concerns for the mothers with her mental stability and her ability to serve as the primary custodial parent. It sounds like she's traditionally done that. It sounds like she's struggled for one reason or another. There's indication that the father makes has a good monthly income. The mother's is less so. So, and I don't know what her take is on all of that. I don't, you know, it sounds like the relationship with the eldest daughter is strained at best between father and I think it's Chloe. And the mental health issues are not new issues. These have been in place for a period of time, and there's been concerns raised about the mental health issues throughout the parties' relationship. And then there's, you know, issues of combat and the impacts of combat and that mental health crisis. So the concern is that, you know, frankly, in the back of my mind, recognizing that there's proper service on Ms. Johnston, and she wasn't here last week and she's here this week. I have some reservations, some really strong reservations about entering a parenting plan where Mr. Johnston's, you know, he seems to be somewhat forthright about his struggles. And that those raise enough concern that, you know, right now it sounds like the mother likely has the children the majority of the time, and that there's that DVPO which prevents conversation or discussion about any visits. So the father's missing out on visits. I'm assuming, I'm making that assumption. I don't know if that's the case. I assume that's the case. Should he have visits? I think so. Should the court have a semblance of assurance that everybody's going to be safe? I don't know. I don't know. And so, and yet sometimes people will be served and they'll choose and to not pursue things and say, just whatever, that's my decision. I am choosing not to respond because I know what'll happen. Things, the default will go through. And yet there's enough kind of glimmering red flags flying around in my head about potential safety issues for both parents in relation to the children and their well-being, that if I make an order here today, obviously it can be changed.
If I may.
Go ahead.
Yeah, and so, yeah, and to, I certainly could not, in good faith, say that any of the observations of the court are you know, incorrect. I appreciate again, the court, my client, myself, we are operating outside of the status quo, little outside of normal. Again, obviously, I had anticipated this being a little bit more adversarial, maybe you being able to flesh this out a little bit better. I would point out, though, if taking into account the court's concerns and as valid as they are, one thing that I think is clear is that, and I think the court pointed this out, and then again, at this point, it's at least uncontroverted on the record, is that there are concerns in both households, probably, and I think that's legitimate, and that for whatever you know, reasons that have got us here, mom certainly, I think, is undisputedly the primary parent. And so maybe if the court would be willing to, because as the court mentioned, I don't think it helps anyone for us to not take some action today. But maybe what the court might want to do, and I would be open to this. Again, I don't have specific authority from my client, but given what the court is suggesting or concerned about, perhaps the court would consider some sort of ramped up parenting plan, give us some immediate parenting time, albeit maybe, you know, small visits, short visits. I don't know if the court I don't know that supervised visits are necessary if the court's going to make them short, you know, several hours a day, maybe on, you know, 2 of my clients' off days or something like that per week. But then in addition, maybe the court would be inclined to maybe, because we have the vacuum of information, in my career, I have found that often a very good way to get more information to the court in an efficient way for both parties would be to order a guardian ad litem or some other fact finder to get involved. It's a little bit out of the ordinary, because normally when we have a clear parenting schedule, again, mom, I don't think it's disputed that mom's the primary parent. On the other hand, I don't think the court's incorrect that there are some concerns from both sides, and perhaps a guardian ad litem could make some recommendations that the court could take on in a further order that says, hey, maybe these services are appropriate in this household, these services are appropriate in that household, and maybe the concerns about, dad's household, maybe not as much of a concern, maybe they're more of a concern. But I think that at this point, given where we are and given the status of the case, I think it would be a good idea for us to have some sort of structure and guidelines for moving the case forward. Obviously, if we walk away today without any sort of order, then we're no further. We haven't advanced the ball, and we may just be looking at waiting out the clock until my client can default mom, in which case I'm concerned from what I'm hearing from the court that a default order might just create even more of the problems that the court's concerned about now. And I appreciate that that's a structural issue that would be problematic. So I don't know if that's helpful for the court or not, but again, on the fly, maybe that's something we can do.
Yeah, I appreciate that input, Mr. Field. Thank you. I appreciate that very much. The suggestion on the guardian ad litem is well taken. So I'll do that. And we have, it's somewhat odd in that there's only one party here so Mr. Field, I'm going to read off the list of 3 individuals who are next up on the guardian ad litem registry. You can object to one of them, and we would not choose that person, obviously, and then the Ms. Johnston would have opportunity to strike, but she's not here. So I think we'll hear from the clerks who those next 3 are. Keith Lawrence. Amy Turnbull. And Ann Height.
Ms. Height would be just fine, thank you.
So
generally, I did the opposite of what you suggested, Your Honor.
Okay, yeah, generally with the 3 that are listed, we kind of go in, that's kind of the pecking order, so to speak, or the hierarchical order. So if you have concerns with Mr. Lawrence, then you would strike Mr. Lawrence. Then if Ms. Johnson had concerns with Turnbull or Height, she would strike one of those 2. So
okay. Well, to respond in that capacity, Your Honor, just to follow the rules of the court or the suggestions of the course, I don't have a strong objection to Mr. Lawrence, so that would be he would be fine.
Okay, all right. So I'll appoint Keith Lawrence to serve as guardian ad litem. The father, it'll be on a private pay basis. The mother, I'll make it county pay basis at the time being, because I don't really know her finances very well. And so we'll anticipate that guardian ad litem to investigate all issues related to a parenting plan and safety and well-being of children. And that obviously encompasses mental health of both parents and also the children. And so Mr. Field's suggestion as far as a default, I am going to grant the default. There's been no response here today. And I will nominate the mother as primary custodial parent. And I want to have professional supervised visitation for the time being for father. And my thought is on the first week end of the month, dad would have supervised visitation from noon until 5 p.m. on Saturday. Every Wednesday, he would have visits from 5 to 8 p.m. with the children supervised. And then the following week, it would be Sunday. As opposed to Saturday, and then kind of alternating. So one weekend it'd be Saturday, the next weekend it'd be Sunday, and the next weekend Saturday from noon to 5 p.m. They would all be supervised. I recognize that's expensive, and I do recognize that there's a little wiggle room probably in the budget to hopefully make allowances for that, for the father to pay for that. I want to have a quick turnaround time with the guardian ad litem to see if he can make contact with Ms. Johnston to see if there's any information she can shed on the situation. So I'd like to review this and have that report. And this may be optimistic, but we would be looking at 1, 2, 3, 4. To have a report by April 4th, have an interim report by April 4th, and we would be back here on April 4th at 9 a.m. to review that interim guardian ad litem report. Really, I'm just kind of looking for any feedback from Ms. Johnston and Mr. Johnston as to 1, how things have gone with the visits, and 2, if there's any just what's happening, because we're kind of flying in the dark here.
Yeah, Your Honor, just real quick, the midweek, you said Wednesday, 5 to 8. Could we do Thursday? I think that will work better with my client's work schedule.
It's fine. Yeah, that's fine. That's fine. I'm going to reserve on attorney fees. I'm going to reserve on child support. I think hopefully we can get more information on that, but we can certainly address those issues again on April 4th.
Great. Okay, Your Honor, and again, I don't know what the court's preference is. Under normal circumstances, of course, I would be drafting an order and forwarding it to the other side in the normal course. I don't know. Let me double check. I do not have a good email address, but I also hate for mom. I guess we can come back on this docket and I can present.
Yeah. Well, we could approach it in one of two ways. We could come back with a proposed order, or I could simply do a bench order. It's pretty straightforward as far as the guardian ad litem appointment, the time and the supervision. It's really pretty straightforward. So I think I would like to do that and just send it out, either snail mail or email to the.
Your Honor, I think that actually is yes, that's a very good idea.
Okay, let's do that. So I'll get that and I'll forward that to the parties once it's complete here in the next few hours.
Excellent.
And then any other items, Mr. Fuel?
No, Your Honor, not from us.
Okay. All right, thank you. All right, that'll conclude that matter for today. We'll see everybody on April 4th. And that concludes the hearings for today's docket.